Well, hello there, and welcome again to the Employment Law Show. Good to have you along for the next half hour. Host John Scholes, and joining me, the boss man is here again, Lior Samfiru. Momentarily, Lior will be with us and give you all the information you need. We are getting rid of the myths and misconceptions about employment law. This is stuff you need to know if you have a job, so it is the vast majority of us, right? Contact anytime, help@employmentlawyer.ca or simply employmentlawyer.ca. That would be the website you want to use. Coming up, lots of stuff. Main topic, what you should know about workplace investigations. That's on the way shortly. And we'll get to a bunch of phone calls from our long-running radio shows across the country. Good stuff in those phone calls. You're asking good questions when you join us on a weekly basis, so we play them back and talk about them, again, to further your education about workplace rights. That's all coming up. But we always start off, Lior, the week that was. Your time to shine, pal. How are you?
Thanks, John. No pressure. Great to be here, of course. Great to talk about employment law. Great to try to educate as many people as possible about workplace rights. This is such an important topic, of course. I have people calling me every day, all day, and it's not because they're just curious. It's because these are real issues that people are facing in the workplace, whether it's a bad boss, whether it's rules that don't make sense, whether it's demotions, losing your job, having your hours, your pay changed, you name it. I deal with these issues every day, and on this show, we try to take those main topics and tell you about them so that if you're facing that issue, you'll know what to do, you'll know what to say, and of course you'll know what the law does for you. We can only cover so many topics on the show. So if you want to continue the discussion beyond these 30 minutes, very easy to do. You call me in the office, you email me in the office. We'll give you that contact information throughout the show. I want to have that conversation with you, so don't be bashful. But as John said, I always like to start off with the situation that came across my desk over the past week. I spoke with a gentleman who had been asked over a period of 3 months to work a lot of extra hours. Company was going through some sort of a restructuring, and he and his colleagues had to work a lot of extra hours. Well, after the 3 months was up, he hadn't gotten paid anything extra for it. He went and he talked to his employer and said, well, I need to get paid overtime for the last 3 months. I was working 50, even 60-hour weeks. Where's the overtime? Company was not very happy, and they say to him, well, we all had to pitch in. You need to be a team player. The company's going through a bit of a difficult time. Do you really want this overtime? He said, well, yeah, I have a family to support too. I need this overtime. Well, about a week later, he gets his overtime. He got it all paid, and he thought that was it. Well, fast forward another week. He gets called into a meeting, and he's being told, for business reasons, we are letting you go. He called me right away. He wanted to understand what his rights were in this situation. Listen, I am not a mind reader, but to me, this absolutely sounds like he's being let go because he demanded overtime, because he had the audacity to ask for what he is legally owed. Well, guess what? That's illegal. You cannot be let go for standing up for your rights. You cannot be let go for asking for what the law says you should be getting. In this case, it's overtime pay. Doesn't matter if the company's struggling or not. If they're asking him to work, they have to pay him for that work. In this case, he asked for overtime. They reluctantly paid it, and then they punished him by letting him go. We call this a reprisal. It's illegal. So if you're ever in a situation where you're not getting paid something, your rights are not protected or enforced, you have the right to demand it. You have the right to ask for it. You have the right to make sure that you get it. And the company can't do anything to you. There's going to be significant repercussions to this employer for what they've done. I'll deal with that. But a reminder, if any of this happens to you or sounds familiar, you have to call me right away.
Is there a difference as far as overtime rules are concerned, whether you're an hourly employee, full-time employee, salaried employee? Doesn't make any difference whatsoever?
So generally speaking, overtime applies to everyone that works those extra hours, depending on your province. It could be a 40-hour threshold. In Ontario, for example, it's 44 hours. If you work those extra hours, you get paid overtime at time and a half. Even if you're on a salary, you still get that paid. So hourly, full-time, part-time, if you work the overtime, you have to get it paid.
Is that something you can go to the ministry for? Because we often caution people not to go to the ministry for so many matters when it comes to employment, because you can get in deeper water doing that. Can you do that in that case, or just come straight to you? I mean, you can always come straight to you, but can you go to the ministry?
So generally speaking, the rule that you should follow is if you lose your job, you cannot go to the Ministry of Labor. You cannot go to the Labor Board for help with that. What you can and you should, in fact, go to the Ministry of Labor is if there's issue about money owing to you, vacation pay, overtime pay, they didn't pay your commission, that you can go to the ministry, they can help you. When it comes to losing your job, can't help you at all. To enforce your full entitlements in that situation, you have to call me and get that advice.
As I mentioned off the top, employmentlawyer.ca is the place you want to go anytime for all kinds of education on the show. Also, pocketemploymentlawyer.ca works as well. Radio shows, Lior and I have been doing this for coming up on 11 years. I think we've been doing those across the country. We get great phone calls every week. You guys always call in. You have wonderful questions. Like to play them back on our TV show and talk about them a little bit. We got 3 lined up for the show today. Let's get to phone call number 1 right now.
Real estate agent. I've been with this brokerage for almost 5 years. I was considered more of an independent contractor, and because of the way that we were employed, the CRA viewed us as employees to like an extremely stressful work environment. I took a leave of absence, but they terminated me. They offered me a 3-week severance pay, basically my average. Kind of a little stuck on what to do, to be honest with you.
You know, there's a few things to unpack here, John. So let's start with the idea of real estate agents and with their role. I see this often, been doing this for 21 years now. Oftentimes what I see is with real estate agents is that they're misclassified. They're called independent contractors, but they're really employees. So, you know, what's the rule? If you look like an employee and you act like an employee, you are an employee. It doesn't matter what you call yourself or what the company that you work for calls you. Usually with real estate agents, you are employees. Same thing with truck drivers, many other positions. So in this situation, he was let go. He has to get paid severance as an employee because he is one. Now, beyond that, he was on stress leave, then gets terminated. You cannot be let go because you're sick. You cannot be let go because you took a medical leave of absence. That's illegal. That could be a human rights violation. So that's issue number 2. And of course, issue number 3 is, well, how much severance? He was offered 3 weeks after those 5 years of employment. Well, let's see how much he is really owed, because guess what? He's been wrongfully dismissed. Let's go and use our severance calculator tool. You can find it, of course, at pocketemploymentlawyer.ca. And let's see when we plug the information how much severance he is really owed. So we know that he's a real estate broker, been there for 5 years, 35 years of age. Company says, yeah, 3 weeks, we're going to be nice to you. Except you see there he's owed right around 6 to 8 months. Not days, not weeks, 6 to 8 months of severance. So that's why he's wrongfully dismissed. And you can do the same for yourself. Just go to pocketemploymentlawyer.ca.
Now, as far as real estate agents, that's one of those careers where, you know, the income, it's ebb and flow, it's high, it's low. How do you calculate that severance of 6 to 8 months?
A lot of people have income that is not steady. Sometimes it's higher, lower, there's commission, there's bonuses. So the rule is very simple. We average it out. So when it comes to your severance, we look at an average. Depending on how long you've been there, maybe it's a 1-year average, 2 or 3-year average. And that's the figure that we use to calculate your severance, because your severance has to address all components of your compensation, not just your salary. And if your company doesn't calculate that properly, that too can be a wrongful dismissal.
And as Lior said, you could use that calculator yourself on your own time. How do you do it? Pocketemploymentlawyer.ca. Okay, phone call number 2. Lior's coming up right now. Let's get to it.
I was just calling in for a son. He was dismissed, hired away from the company he was working with, and he worked there for 3 months and they fired him.
How long did he work for the first company, the one he was recruited from?
12 years.
12 years, they recruited him, they let him go after 3 months.
Yes.
And did they pay him any severance?
I think they paid him 2 weeks is all.
Big surprise coming up.
Yeah, you and I were chuckling to each other as we were listening to this call. And the reason, because we've talked about this on our radio shows, we've talked about this on this TV show. And this is the idea where you're not looking to leave necessarily. Another company comes to you and it says, we have a better offer for you. You should leave your employer. Fine, okay, you do that, and then things don't work out, they let you go. You feel, well, wait a second, this is unfair, right? I had all this time with the previous company, I left them, now what? Well, the law understands that. So if you're recruited from another job, we call that inducement. You're induced to leave another job, and then you are let go. You're owed enhanced severance that recognizes the time with the previous company. So in this particular situation, he had 12 years with the previous company, only 3 months with the new company. Well, when it comes to calculating the severance, he's now a 12-year plus employee, and he's owed severance. So he could be owed a year's pay or more. So remember, if you're recruited from another job and then let go, you may be owed enhanced severance.
We got one more phone call to get through, but we're going to do that on the other side of the break and get to our main topic, what you need to know about workplace investigations. That's on the other side, but you can always reach out anytime to Lior and his crew at employmentlawyer.ca. Lots more of the Employment Law Show is coming right up. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back to the Employment Law Show. Thank you so much for hanging in during the break. We got to our main topic, is what you should know about workplace investigations momentarily. But I mentioned phone call number 3, Lior. Let's get to that right now.
I have a friend who's working right now. She has been diagnosed with cancer. She was off of work for a while. She has since come back. She's on modified duty. However, the boss is giving her a little bit of a hard time, wanting her to possibly go back to her regular job. What is her right?
Yeah, and this is a very common question that I get when someone is sick, they're not able to do their job, and the company is not being particularly helpful. So it's important that we understand what the law says in this situation. It's actually very straightforward. A company has an obligation to accommodate. So if you have a doctor's note saying you need help, you need support, you need another job while you're recuperating, the company doesn't have much discretion here. They have to make it happen if at all possible. And even if it's difficult, even if it costs them money, they still have to do it. And if they don't, that's a human rights violation. So in this situation, I would say, make sure you have the doctor's note. Make sure the doctor's note is clear about what you can and cannot do. If the company doesn't accommodate you, call me. Often just a letter from me may change the dynamic altogether, but that duty to accommodate is not negotiable and very, very important.
Again, thank you so much for the phone calls on the show today. I want to reach out anytime. EmploymentLawyer.ca, give you a list of radio stations across the country where you can not only listen but join in and make that phone call yourself. It might appear on a future show here as well. Okay, here we go, Lior. What you should know about workplace investigations. Number 1, employers are obligated to conduct a workplace investigation when an employee complains about harassment or discrimination. Yeah.
So we have laws, very strict laws across Canada dealing with workplace harassment and how an employer has to address that. So the first thing to remember when it comes to investigations and harassment is the company has to take it seriously, very seriously. That means they can't ignore it. They can't say, well, you know, boys will be boys. I've heard that saying before. They have to take it seriously and then conduct an investigation. They have to involve everyone involved, get information, and find out what happened. Now, sometimes that may mean bringing in an outside investigator. The investigation may be too complex for the company to do it itself. They have to do that even if it costs money. It's not cheap, but they have to do it. And if a company doesn't investigate, doesn't take it seriously, there's all kinds of repercussions. None of them are good at all. So you should always feel comfortable as an employee to demand that the workplace be healthy, that harassment be addressed, and the company then has to investigate and fix that problem.
Point number 2 is a logical step forward, and that is if the employer fails to conduct an investigation, or doesn't take action after completing one, the employee may be able to resign with severance.
That's right. So none of us, by the way, should ever work in a workplace that's full of harassment and a poison work environment. We have a right to work in a proper and healthy work environment, and it's the company's job to make that environment proper. So if you told them about harassment and they haven't addressed it, they dropped the ball on it, well, you don't have to continue working there. That may be what we call a constructive dismissal, by the company not treating you properly, not resolving this workplace issue. Number 1, that could be a human rights violation depending on the harassment, but beyond that, it's a constructive dismissal. The company, because they've done something wrong, this now allows you to treat this as a termination, not continue down this unhealthy path, get your severance, and move on. If you want to do that, you have to call me right away.
And point number 3 for this segment of this show, Lior, is this: an employee who was fired following a workplace investigation may still be owed full severance pay.
That's right. So if you're let go, okay, in this type of a situation, you're owed severance, but there could be other potential consequences. We talked before on the show on this concept of reprisal, that you cannot be punished for standing up for your rights. Well, that definitely applies when it comes to workplace harassment and investigations. If you demand that your rights be enforced, that the company deal with it, and they don't, and they let you go, yeah, you're going to be owed severance, of course, but there's going to be other consequences. So you should always feel comfortable advocating for yourself, demanding that this matter be addressed. It's improper for the company to ignore it, and if you need help in pushing that company to do that, I'm right here.
Good stuff. We got more viewer questions on the way, which we'll get to on the other side of the break, so stick around for that. And maybe your question on the way shortly. In the meantime, how to reach out, employmentlawyer.ca, the website, and that email address, always help@employmentlawyer.ca. You're watching the Employment Law Show. Stick around. We're coming right back. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. And welcome back to the Employment Law Show. John Scholes, your host, and Lior Samfiru, always here answering your questions. Reach out anytime, 1-855-821-5900, help@employmentlawyer.ca. And online, the website, of course, is simply employmentlawyer.ca. Okay, Lior, including TV and radio and being a dad and all these different things you do. You also do a ton of live streaming on Facebook and YouTube. The guy never sleeps. Question from it right now for this show. If you want to join in, by the way, at stlawyers.ca, at stlawyers.ca. After working in the oil industry, I amassed a significant amount of overtime, but my boss told me I was not owed any extra pay due to our industry. Is this true?
So there are certain industries that have exemptions from overtime, and it does vary from province to province. One of them is the oil industry. There's other, for example, professionals, doctors, lawyers.
Pool cleaners.
Pool cleaners,
still
yes.
Get over that one.
I guess because of the seasonal nature of the job.
Yes.
You know, construction employees. Yep. By the way, also managers are exempt from overtime. So it's easy to think that in those situations, I just don't get overtime. Well, not so fast, actually, because you may still be owed overtime in those situations if you have an employment agreement that specifies your hours of work or specifies that you get paid over overtime over a certain amount of hours. So if you have an employment agreement that says we're going to pay you for 40 hours and overtime above that, well, the company can't forget that and say, oh, wait a second, you're now exempt because you're in the oil industry or because you're a pool cleaner. No, you still get overtime even in that situation. And I want to kind of break this down. We touched on this earlier. When it comes to overtime, even if you're on a salary, if you're in a non-exempt position, in Ontario, for example, overtime is paid over 44 hours a week. That means that your weekly salary is good for up to 44 hours a week. So how do you calculate your overtime? It's very simple. Whatever you earn in a week, you take that and you divide it by 44. That number is your hourly rate. Time and a half of that is your overtime rate. So anything over 44 is your overtime rate. Remember, even in an exempt position, managers, oil industry, pool cleaners, professionals, you may still be owed overtime in some situations that you're not sure. Call me, happy to help.
Would that be one of those secondary things you should be looking at in an employment agreement, a line about overtime? Because most people wouldn't even dream of looking at that for an employment agreement, right?
Absolutely, and that's something I always look at when I look at an employment agreement. You know, if you're in a position and it says overtime only kicks in after this amount of hours, you want to be aware of that. You don't want to agree, if you're working, in the oil industry, you don't want to agree that overtime will only kick in after 55 hours a week. That's a lot of hours. So you want to be mindful of that as well. But John touched on employment agreements. Of course, such important documents. You want to be careful. It's not just about how much salary you get and how many weeks vacation you get. There are many things that are important and potentially problematic with that employment agreement that you cannot ignore. For example, a term that limits your future severance. Employers use that all the time, John. By signing an employment agreement, you also may be agreeing that down the road, if the company ever lets you go, they're going to give you a fraction of the severance. That could cost you tens of thousands of dollars. I've seen situations where that could have cost someone hundreds of thousands of dollars. Be very mindful of that. It could also give the company the right to put you on a temporary layoff, which they don't otherwise have a right to do. It may give the company the right to change your hours, change your pay. Again, not something that a company has a right to do unless you sign an employment agreement that gives them that power. So anytime you are presented with an employment agreement, whether it's a brand new job, you're excited to start, or maybe you're an existing employee and you've been presented with a new agreement, let me see it before you sign. I can tell you what it means, what it does, and even give you some thoughts as to how you negotiate better terms.
Again, anytime you want to do that, as you should every time, as a matter of fact, with an employment agreement, help at employmentlawyer.ca or simply employmentlawyer.ca, the website. For more contact details, want to get into our rapid fire segment of the show, Lior. 3 questions. You know what, we're going to lay back, take a bit of time with these this week because they're important ones. Number 1, can an employer terminate you when you've had a doctor's note instructing you to take time off work for a sick leave?
No, you cannot be let go because you're sick. You cannot be let go because you're going to take time off work. You cannot be let go because of the inconvenience that this may cause to your employer. Now, if your employer is letting go half its workforce, you're one of these people, and you happen to have a doctor's note, the doctor's note itself is not going to save your job. But you cannot be let go because of that doctor's note. That can't even be part of the equation. You cannot be let go in that situation. What can the company do? Very simple. We touched on this earlier. Accommodate. Do what the doctor says. They can't question the doctor. They can't ask for a second opinion. They can't disbelieve the doctor. Man, what a powerful tool that doctor's note is. Get it? If the company does anything to you, let me know. It's going to not stand, and the law is going to come down really hard on that employer.
And if the boss says, well, Lior, I know you've been off for a while, but you've used your 10 sick days. You got to come back to work, right?
I see that all the time. Well, we have 10 sick days, so you can only be sick for 10 days. I've even seen situations, John, where the company says, well, you've been sick 12 days, so we're going to punish you.
Wow.
Let that be a lesson to you not to get sick. How ridiculous is that? You're getting punished because you were sick. That's helpful. So no, here's how this works. The number of sick days you have really only addresses how many days the company is going to pay you while you're off. It has nothing to do with how many days you can actually be off. So if the company has 10 sick days and you're off for 10 days, they'll pay you for those 10 days. But if you need to be off for 50 days, that may mean that they don't pay you for the rest of the days, but you can still be off. There's various other options that you have. You can apply for EI sickness benefits. You can apply for short-term disability or long-term disability so you can get paid. But the number of sick days that you have nothing to do with how long you can be off work. That issue can only be decided by your doctor.
Question number 2, are employees obligated to tolerate bullying in the workplace?
Oh my gosh, this is such a topic. Always kind of upsets me to think that there's so many people out there that are suffering in a poisoned work environment. They go to work every day with a knot in their stomach, dreading coming into work. That should never happen. You don't have to tolerate that. That's not an acceptable part of your job. That's not what you signed up for. So if you're dealing with the bullying, with harassment, with a poisoned work environment, with mistreatment, doesn't matter if it's a colleague across the hall or your boss, improper. What you do with that in that situation is you try to get the company to fix it, to meet its obligations. So talk to HR, talk to the owner, talk with whoever the right person is in your company and let them know. As I was saying earlier, they have to take it seriously and investigate and fix that problem. If you tried and you couldn't do it, they won't deal with it. Or maybe there's nowhere to talk to. It's a tiny company. Well, then you get me involved. There's various things that I can do to help you. But no, you should never accept, tolerate, or continue working in a poisoned work environment.
And that was kind of the question I was going to lead to. There's 3 people. It's not a company with thousands of employees where there's hierarchy in HR. It's 3 people working in this business, and the top guy, the boss, is the guy harassing you. You feel like you've got nowhere to go.
And realistically, in that situation, you don't have anywhere to go internally. If you're working with 3 other people and the boss is the one creating that poison work environment, well, who are you going to go to in that situation? Well, not the boss. Well, then because you can't deal with it internally, we have to deal with it externally. That's where I come in. So what I would do in that situation is I would get you out of there, okay? Because I don't want you to continue working in that poison work environment. And then we deal with the compensation that you're owed because of that situation. That could be a constructive dismissal, a human rights violation. It could be other aspects of it as well that entitle you to compensation. The key, though, is this. When it comes to harassment, always, if we're going to pursue the matter, I need to have a way to prove that harassment. You remember, the boss that's harassing you is not going to admit it, right? They're not going to say, yes, of course I did it, my bad. They're going to deny it. They're going to say it never happened, or no, you misinterpreted it. So let's always think about, how do we prove it? Do we have an email or emails or text messages confirming what happened? Is there a recording? You're allowed to record, by the way, if you're part of that conversation. Is there someone that's willing to corroborate that, okay? Even though I always believe what you're telling me, I still have to be able to prove it to someone else. So it could be as simple as, if you're being mistreated, your boss did something to you, go write it down, or send an email to someone confirming what just happened. Create that record. And that allows us at that point to come back and say, here's my proof of that harassment. Now I can show that it really happened, and now my rights are able to be enforced.
By the way, anytime you have questions, might appear in this segment of the show, help@employmentlawyer.ca. We invite you to send those in all the time, and we'll get to them for sure. Number 3, Lior, is this. 3, there you go. Can employees refuse to be placed on a layoff? Massive topic over the last 3 years.
Oh, my God. And it seems like when the pandemic first hit, that was the only question I've been asked, but still a hot topic. Can you refuse to be placed on a temporary layoff? The answer is, well, yes, you can, absolutely, and you should. Now, that doesn't mean that, well, I've refused, so I'm coming into work anyway. Too bad, company, here I am. No, you call that trespass. If the company tells you not to come into work, you can't show up. But what I am telling you is that you don't have to accept this reality. You can consider that as termination. We call this constructive dismissal. Because your employer doesn't have the automatic right to put you on a temporary layoff, you may choose to look at that as a termination. To say, by putting me on this temporary layoff, it's as if you fired me. I now can walk away and get my severance. And the reason why I said not only can you do that, but you should do that, is if you don't do that. If you sit at home like you've been asked to do, and then you come back 3 months later when they call you back, by doing that, you've given them the right to do it again, and again, and again. And that's a very bad place to be in. So you have only that one opportunity to stand up for your rights. By not standing up for your rights, you're giving up your rights. So if you're put on a temporary layoff, think about what I just said. Consider this maybe a constructive dismissal. But of course, before you walk away, you have to give me a call.
Again, is that something they can sneak into an employment agreement? We have the right to put you on temporary layoff whenever we say we can. Right?
So the law says that you have all these rights, right? But the law also says, hey, you're an adult, I'm an adult. If we want to agree to certain terms, we're not going to stop you from doing that. So you can actually agree to give up rights preemptively. And what John said is a great example. Company doesn't have a right to put you on a temporary layoff. I was just very clear about that. But what you can also end up doing without even maybe thinking or realizing it is agreeing that they can, signing an employment agreement that says, there's like just one line there that says, hey, we have a right to put you on a temporary layoff if we choose to. And by agreeing to that, you've now given up the rights that you had even without thinking about it. The company can put you on a temporary layoff. They can put you off work whenever they want for maybe even months at a time. Don't do that. Be careful with what you sign. And the rule that I always follow is that if you can't live with it, well, don't sign it. You can negotiate these things out. You absolutely can. If you want to know how, if you're in that situation, if you're not sure what that agreement means, as I said, just call me right away.
Well, it's like you've always said, you know, if your boss said we're going to give you a 50% haircut, 50% pay reduction, you're going to say, no, absolutely you're not. Well, what's a temporary layoff? It's the whole thing.
It's 100% reduction. So just, yes, you won't ever question that a 50% reduction is illegal. Well, a temporary layoff is 100% reduction. That's why it's illegal unless you sign something that gives the company the right to do it.
Great questions, fantastic show. Thank you so much for tuning in for the last 30 minutes. Again, always your contributions to the show are welcome. You can tune in to the radio show. Simply go to employmentlawyer.ca to find a station across the country, including here in the GTA, where you can catch us weekly, and emails help@employmentlawyer.ca. And finally, that phone number, one more time to reach out to Lior, 1-855-821-5900. We'll catch you again on the Employment Law Show. Thanks for tuning in.